today. I understand it was quite hot yesterday, so hopefully it will be with the weather outside a little cooler. I'm Jane Horvath, and I'm Apple's Chief Privacy Officer. Today, I have the pleasure to facilitate a panel with some outstanding representatives of the privacy and academic community, each one representing a key group of stakeholders who play a role in the global governance of privacy that we're discussing further with this panel. Of course, there are many others. It is a privilege to be with you today. It is a little over a year since our CEO, Tim Cook, spoke at this event. He called for a new season for our fundamental right to privacy, one where worldwide privacy laws and new international agreements that realize privacy values would emerge. And since that time, we've witnessed something of a privacy spring with the arrival of foundational privacy regulations in many parts of the world. The past 2 years have seen privacy laws passed protecting individuals in Brazil, China, Sri Lanka, Zambia, the UAE, and in 4 states in the US. And, importantly, existing privacy laws have been strengthened in many parts of the world to solidify fundamental protections in the face of emerging threats. We at Apple have welcomed this universal response, a response that has been led by many of you in the privacy community. While the law can and does provide a strong baseline for privacy rights, it certainly cannot stand alone in propelling privacy rights and values forward. We all have a role to play, and at Apple, we recognize that we have a responsibility to go further, much further in many cases, and this is something that Eric will return to in his remarks. Over the years, Apple has consistently designed powerful privacy protections that deepen our own privacy principles and affect changes across the industry as a whole, going over and beyond legal requirements. Of course, we are always happy to see others in industry follow our lead or indeed introduce their own privacy initiatives. We all benefit when we compete on privacy. There is still more to be done by all players across the globe. What is clear is that it remains difficult for consumers and citizens to understand and control how, where, and for what purpose their data is being collected, often because there is simply no transparency or meaningful choice. At Apple, we consider that we have a responsibility to take concrete actions to address the transparency and control gap. Initiatives such as App Tracking Transparency Framework, Privacy Nutrition Labels on the App Store, and App Privacy Report put control in the hands of users. We will continue to defend strong encryption without backdoors, because backdoors threaten our privacy and security. We don't know of a way to ensure that backdoors can only be used by certain trusted actors. Backdoors are not partisan. Across the world, Apple continues to advocate for strong encryption standards so that our laws do not become a means for compromising our privacy or mandating vulnerabilities. We have seen a number of recent developments which could impact encryption here in Europe, for which we remain vigilant. I know that this audience is most vigilant also. It would be a great irony if Europe is the place where we see the first real attack on encryption. Apple understands that we must continue to deliver upon our commitment to privacy, but we are only one of the actors in this global arena, and many more stakeholders have a voice, a platform, and a duty to contribute to shape the future of privacy beyond regulation. Coming back to what we hope to cover with this panel, multistakeholderism. I am so sorry, that is just a tough one to say, is a key component of the global governance of privacy. The very idea that progress can and should be achieved in addition to the black letter of the law, though the effort of all those who share a common interest in furthering privacy. And that, as a fundamental human right, privacy should be available to all individuals and not dependent on a certain framework or set of circumstances to come to life. This panel has set out to provide at least a start in answering some of the very important questions for us here. Can laws on their own achieve enhanced privacy worldwide? Who are the privacy stakeholders and what are the benefits and challenges? What is the responsibility of each of the stakeholders? How do they hold each other to account, and how do they bring it all together? What role is there for privacy-enhancing technologies, and how can we harness those developments for good? Ultimately, is the future of privacy being shaped beyond regulation? Who's shaping it, and in which direction do we want it to go? With that, I would like to ask Lorenzo to take the floor. Lorenzo is an assistant professor in data protection and cybersecurity law at the Tilburg Institute for Law, Technology, and Society. He previously worked at Delft University of Technology and at Tilburg Law School and held an honorary lectureship in the Australian National University College of Law. His current research interests revolve around proportionality and the balancing of competing rights and freedoms, primarily privacy, data protection, and security.
Thank you. It's great to be back after 2 years, and it's great to see you all again, or for the first time, depends on the circumstance. So when I read the description of the panel, what struck me the most were the last two words, beyond the regulation. And the reason is that I don't think there's anything beyond the regulation in the global governance of privacy. Nothing. And before the engineers in the room start putting together their 3D printed guns, I should make clear that by regulation I mean something much, much broader than the law alone. And that might be due to where I work, how I was brought up. The Tilburg Institute for Law, Technology, and Society doesn't really study one field of law like public law or private law. We study socio-technical change. We study how to regulate and to govern socio-technical change, and we know full well that the law is only one of the ways where we can regulate privacy, contribute to privacy from a global perspective. So this is what I wanted to briefly talk about today. First, I'll outline what I think is a good cognitive framework to think about regulation, and then I'll try to answer a couple of questions raised by the panel description, namely whether laws alone can achieve enhanced privacy for individuals, and whether privacy should be achieved through multistakeholderism. So many understand regulation as a form of command and control directive, top-down from the state, within the state, through the use, mostly through the use of legal rules backed by sanctions. That is a centered view of regulation. It's very old. We should stop thinking about regulation in those terms. The centered perspective on regulation, on the other hand, they recognize that privacy and data protection are not centered on the state, but they are rather diffused throughout society. So regulation is not really just a rule backed by a sanction and supported by the state's authority, but it's rather the function of social control as performed by a multiplicity of actors within, say, the data protection chain. And indeed, the rights of privacy and data protection in particular are subject to the action of a multiplicity of actors that have regulatory capacity. So the ability to enact social control effectively and willingly. And we may debate the democratic legitimacy of such a form of regulation. We should do so. But the stuff is what the stuff is. regulatory forces abound and they are not limited to the law. So I usually refer to the work of Professor Julia Black when I talk about regulation. She's one of my favorite scholars. And she, in a paper, she provides 5 main themes that suggest why a decentered understanding of regulation is better than a centered understanding, especially, in my opinion, when it comes to the governance of privacy. And the first theme is complexity. Privacy and data protection issues are the result of the interaction of a multiplicity of actors and factors, most of which are not fully known and understood, and most of which are in a state of constant flux. So complexity is the first theme that suggests that a decentered understanding of regulation is a better framework than a centered one. Then there's the fragmentation. Power, control, and knowledge are fragmented within society. And we cannot really expect a single actor, not even the state, to have a sufficient amount of competence to solve problems as complex, as multifaceted as the ones we face. And then there's autonomy. Regulatory actors and regulatees are not static. They continue to develop in their own way. So in this must be seen within the frame of interaction and interdependencies, which are the 4th area that suggests how the centered understanding of regulation is a better conceptual framework. Regulation isn't really top-down, but it's rather co-produced. It's a bit like knowledge. There's a sort of feedback loop between regulator, regulatees, and the other actors within the chain. And then finally, there is the collapse or partial collapse of the distinction between the public and the private, which sort of challenges our understanding of what authority is, of what power is. And I think from this perspective, it becomes clear that law is far from the only thing that governs and regulates privacy and data protection. And usually when we teach regulation to students at Tilt, we go back to Lessig's work. So media's, or rather social norms, regulate, technology regulates, markets regulates. And we can argue that there are more regulatory forces out there, for instance, media, or the ability and willingness to harness network effects to have particular purposes, which we've seen in recent years in the disinformation area. So my point is that the question whether privacy can or should be achieved through multistakeholderism is rhetorical, meaning that there is no other way. And the question of whether the law alone can achieve privacy for individuals is as rhetorical. It clearly can't. The legal community, the normative community, is not an exclusive mystic policy cabal. We share the burden of regulation with a bunch of other actors. And at the same time, the technical community must come to the realization that they too are a policy community, they too are a regulatory community. The difference between what we do is very thin under some aspects. Then the panel also asks how to engender a privacy paradigm shift without causing stakeholders to seek to block or water down those changes. And I would like to address that too, if I may. And I think the answer is that we don't, regardless of how much I would like to. I'm a privacy absolutist, and I take pain over change any day of the week. But still, this goes beyond the fact that privacy is necessarily multi-stakeholder by definition, or rather by reference to the mechanics of regulation. But it's rather about what privacy and data protection are at their core. The European Court of Human Rights often says that the search for a fair balance between the interests of the individual and the interests of the collectivity is at the core of the convention. The Court of Justice of the European Union repeats every second day that privacy is not an absolute right and must be considered and interpreted in relation to its function in society. So I think this leads to the conclusion that privacy and data protection were never really meant to be unilateral, and that multi-stakeholderism is really the only way. Thank you.
Wonderful. Thank you, Lorenzo. And I'm going to hand on to Anna Buchta. And as head of the Policy and Consultation Unit at the European Data Protection Supervisor, Anna Buchta is in charge of the work of the EDPS on providing advice to the EU legislators on legislation and policy proposals with impact on data protection and privacy. Her team also coordinates the EDPS work as a full member of the EDPB. In both roles, she's been focusing recently on the interplay of the GDPR and the other Commission proposals for the regulation of the digital sphere, DGA, DMA, DSA, the AI Act, and most recently, the Data Act, including the various emerging governance models. She has extensive experience in data protection and privacy regulations, institutional law, and litigation before the Court of Justice. Anna.
Thank you, Jane, and good morning. Let me just take care of the timing. To follow up on what Lorenzo was saying about, in particular, Lawrence Lessig and his code and other laws of cyberspace, that makes me think of the days when I set out to be a young privacy and data protection researcher all these years ago in KU Leuven, and that was when that book was still relatively fresh, certainly in Europe, and influencing our thinking a lot. So there is this idea that you have the law, which I think he termed as East Coast Code, and then there was the West Coast Code. So all the programs, the software, the architecture of what he discussed as cyberspace. And so the argument was indeed that there is much more to regulation than just laws and statutes, and that this code also play a crucial role, and that therefore it should be of interest to everyone because it can affect and also regulate our behavior. And back in the day, a lot of focus in the privacy community was already on privacy-enhancing technologies. So the Commission was investing a lot of money as part of the framework programs, FP6, FP7, in PETs of various kind, in identity management, software prototypes, in digital, what we now call digital wallets. It was called something slightly different back then. But the idea was, how do we actually implement privacy controls through software controls already back then. So I don't know how many of you remember the P3P, Platform for Privacy Preferences, that actually I was doing some archaeology before this discussion. It turns out it was finalized or officially announced in April 2002. That's almost exactly 20 years ago. It's amazing. So that was this idea that you can actually give users greater control over their privacy on the internet via automated browser controls that do not track, and that was a follow-up to that discussion. Then, in parallel, and as a representative of regulators on this panel, I should probably also touch on the role of regulators. So there was this other concept of privacy by design, which was actually pioneered in the early days by Anne Cavoukian, who was the privacy commissioner in Ontario, Canada. It was picked up quite quickly by the European DPAs as well, and then was heavily promoted by what was then the Article 29 Working Party, so the grouping of European data protection authorities, and ended up in the GDPR as Article 35, data protection by design and by default. So here I think it was clearly an attempt to provide not just incentives, but even a form of legal obligation and binding principle that would underpin essentially engineering, privacy engineering efforts. Today, I think, one way of looking at that is, we've been talking about pets for 20 years. It didn't work then. It will not work now. No business case, whatever. But I think that would be a huge mistake. To my mind, we are rather in a situation when there is this perfect storm finally, hopefully bringing this idea to life. So there is growing awareness, growing public awareness, and the need for effective privacy controls, which I guess there wasn't so much maybe 20 years ago. I think that GDPR and the process that started in many jurisdictions since the Brussels effect greatly contributed also to this growing public awareness. Then, at the same time, what was happening, I think, is a certain crisis of trust following the Snowden disclosures, but also then Cambridge Analytica and similar developments where people really started thinking deeply about, the little crumbles that they leave when browsing the internet, using the internet, and all the surveillance, and that it actually can have real life effects. And then finally, we have this regulatory framework, and by that I mean not only the GDPR with its Article 35, but also the 150 or so different statutes and laws and bills that we already have worldwide, providing baseline privacy protections in many jurisdictions. So this is, I think, not only the baseline, but also incentives for companies operating worldwide to also really implement effective privacy protections in practice. And because none of that is possible or would be possible without effective privacy engineering, this is also something that, and now, a moment of promotion, self-promotion for the EDPS, we have been supporting, organizing since many years what is called IPEN, Internet Privacy Engineering Network. That is an attempt or a group that brings together privacy engineers and data protection experts with background in data protection, with the objective of promoting and advancing what it means state-of-the-art privacy engineering. And so in the past, the group discussed topics such as web tracking, encryption, synthetic data, contact tracing during COVID, obviously. And I'm happy to announce that the next meeting of this group will take place next month on the 22nd of June in Warsaw on the topic of digital identity. So mark your calendars for the next IPEN meeting. Thank you very much.
Fantastic. Thank you, Anna. And on to Alexander Hanf, a privacy advocate who has been working on European privacy reform for 15 years, has a background in computer science, psychology, sociology, and law. His early work drove regulatory change on the use of online tracking technologies in the e-privacy directive. He was heavily involved in the development of GDPR and helped to draft the upcoming e-privacy regulation. He also works as a consultant, is a privacy fellow at Innovators Network Foundation, and speaks on data ethics as a faculty member of Singularity University in Silicon Valley.
Thank you, Jane. I remember coming to this conference. It was my first privacy conference back in 2008. I've been to most of them since then. I've spoken at many of them too. In fact, my daughter was born in 2012 whilst I was hosting an afternoon session in the cave downstairs when a volcano erupted in Iceland and prevented me from flying back to witness the birth of my daughter. So it's a particularly special place for me, CPDP, and it's really nice to be back after the pandemic for the last 2 years. And I want to talk about people, because I think people is what's so important here. As I look at it on the audience here, I can see people I met 15 years ago at my first privacy conference. And I see new faces here as well of people I've never seen before. And that's very encouraging and really inspiring to see that this churning of new people into the privacy and data protection space. And this conference in particular is in my mind, very special because it's the place where people who are passionate about privacy congregate. It's not an IAPP conference, it's not a career conference, it's a conference that matters. So I want to talk about things that matter as opposed to talking about technical solutions, et cetera, et cetera. And in my experience, I've been in hundreds of companies over the past 15 years, advising them on how they can comply with the law. And I can go in and you can set frameworks up and you can set up accountability and you can set up data subject rights management and all these other things that we have to do in compliance, which is frankly incredibly boring and not fun at all. But you need to have these systems in place, right? But even then, even when you have all these things in place, you're not going to be managing privacy well if you don't have a culture in the organization to do that. And this is the mistake I see all the time, this disconnect between different business units in the company. Legal don't understand what marketing are doing. Marketing don't understand what the law requires. The engineers don't have any idea about privacy because they just want all the data, right? Because they might be able to do something fun with it at some point in the future. HR, they just want to get candidates in. They want to keep all their details and monitor the PKIs and everything else. So there's this disconnect within the organization. There's no culture. So when I go into an organization, I talk about why privacy is important as opposed to what they need to do. I'm not interested in scaring companies that they might get fined 4% of their annual turnover or they might have huge reputational damage in the case of a data breach. I'm more interested in making companies understand why this is important, why these fundamental rights, which are here for all of us to use and enable us to live in a free society, why they're so important. So I go in and I speak to boardrooms and I say, look, how would you feel if your granddaughter was subjected to these same tactics and processes that you're subjecting your users to who use your platform or use your products? How would you feel if your grandmother was subjected to these same tactics? Would you feel comfortable in those situations? Take your hat off and think about this as a human being, how this impacts real people. And this is really important because one of the things that's become very clear over the past 5 years or so is the negative impact technology can have on society, particularly on democracy. When we consider things like the Cambridge Analytica scandal and the impact that had on democratic elections and the democratic process across the world. When you consider that psychographic profiling, the technique which was used by Cambridge Analytica was originally invented in the 1920s, yet it wasn't until 2017, 2018 that we really started to understand the impact of that and how that could really create a very dangerous situation for our democracy and our society where people are manipulated. They lose the ability to make free choices. And freedoms, the freedoms that we take for granted, freedom of speech, freedom of movement, freedom of association, freedom of thought, all of these freedoms which we take for granted as fundamental rights within the EU and elsewhere in the world as well, and increasingly elsewhere in the world, these are really very much at risk if we don't start to control the technologies that we use. And for me, technology is incredibly important and incredibly special. It elevated me from a very difficult childhood, a very abusive childhood, and really gave me and empowered me with the ability to elevate myself and to educate myself and to meet new people and share new experiences and gain knowledge. And in around 2005, I started to see this big change around technology, particularly with regards to the internet. I've been using the internet since before the web even existed, going through the Archie archives and Gopher and rummaging through FTP sites of big educational institutions, sending ASCII cow archives to Bill Clinton after his first 120 days in power, just to put a smile on his face after the Waco disaster. So to me, technology has played a very important role in my life, and I want to make sure that future generations have those same opportunities, that technology is used to empower them, to make the world a smaller place, to reduce prejudice, to dissolve borders, et cetera, et cetera. But in 2005, we started to see the emergence of technology being used for control and commoditization, particularly on the internet with advertising and tracking people's every move. And this data that's collected is exactly the type of data which enable companies like Cambridge Analytica to do the things that they do and pose the risks that they pose to our society. And if you look at the situation in China with the social credit system, we can see that playing out in real time. In psychology, which was my first degree was in psychology and computer science, and in psychology we have this phenomenon we call participant observation, otherwise known as the Hawthorne effect, which states that when people are being observed, they change their behavior. Their behavior becomes artificial. So we're no longer human beings making rational choices. We're being motivated or manipulated by emotional triggers as a result of being observed. So that becomes artificial. We're no longer free individuals. We become almost automatons. And we see that in China. So the social credit system in China, where we've seen millions of people banned from travel because their dog fouled on the footpath or they didn't chain their bike up in the most appropriate place on the street, et cetera, et cetera. So really minor infractions which should have in no way any impact on somebody's freedom of movement being used in these ways. And it's almost as if China took Nosebleed, the episode from Black Mirror, and said, hold my beer, right? And took this and turned it into this real scenario. And it's really troubling because people in China now, as a result of that, have very limited freedoms, because everything they do is being observed and monitored and being reported and being scored. And if their score doesn't reach the level which the government have assessed as being appropriate, then they lose those freedoms. And we risk exactly the same situation through the surveillance of all our activities online. So it's not just about tinfoil hat stuff. It's not just about the annoyance of advertising. It's about a real impact on us as individuals, on our autonomy, on our self-determination, on our psychology, on our ability to innovate. The one thing which has the human race where we are now is our ability to innovate. But if we're constantly being manipulated by technologies which seek to push us in certain directions for the agenda of a global corporation, as opposed to things that we want to do and need to do as a society, as a rational human being, then we lose that ability to innovate, because innovation requires thinking outside of the box, right? So it requires not following a line that you're being pushed down. And this is why we are as we are. This is why we've developed as we've developed as a human species, is because of that ability to innovate, because of our ability to communicate and our desire to communicate. So if we constantly monitor everybody and we're manipulating people's behavior through psychographic profiling, or the Hawthorne effect is leading people to change their behavior and become artificial, then what does that mean for future generations? What does that mean for our children and our grandchildren? Will they have free choice? Will they be real free people? Or will they just be a product of a technological factory churning people through school and high school and college, and then through the social interactions online and through the workplace? And this is the real risk to me. This is why I get up every morning and do the work that I do, because I want to make sure that we remain a free people, that we remain or keep the ability to innovate and keep moving forward as a species, to keep solving problems like the coronavirus, the pandemic that we had over the past 2 years, to keep solving problems like the situation in Ukraine currently, or the situation of organized crime or human trafficking and all these other issues that we face as a society. And I think it's incredibly important that as leaders in our industries or in our jobs, in our workplaces, that we raise that culture of privacy awareness within the organization so people understand why this matters, why this is so important. Because if we don't, the future for our children, our grandchildren, is already lost. So there's my thoughts. Thank you very much.
Thank you, Alexander. And on to Dr. Konstantin Boettinger. He is head of Department Cognitive Security Technologies at Fraunhofer ASEC and an expert in information security. He also heads the Department of Cognitive Security Technologies at Fraunhofer AISEC. He has more than 10 years of experience in transforming applied research into high-tech security solutions for various industries. His research focuses on the intersection between artificial intelligence and cybersecurity. He completed his PhD at Technical University Munich and is currently an executive MBA candidate at the University of Oxford. Prior to joining Fraunhofer AISEC, Konstantin studied mathematics and physics at Heidelberg University. Konstantin.
Thank you very much. Let me connect to this point, to the ability and the desire to communicate. For this, we need a common language. So my point is that to have a common language, we need privacy standards on a technical level. And these then can form the basis for further regulation. And let me give a perspective from security. Security there is a very good standardization for cryptography. And we need this. Without these standards, we would be lost. If I go anywhere in the world and say, okay, give me an AES, a certain key length, people know what I'm talking about. And it's important to have this common language. We could also look at the common criteria, where we say, okay, wherever I'm at, and ask for a certain evaluation level, for example, for a security chip or a smart card, then people roughly understand what's been talked about. Now, let's have a look at privacy technologies and, for example, confidential computing. What does it mean for confidential computing to really be confidential? Is it some kind of homomorphic encryption? Maybe. Which parameters? We don't know. Maybe some secure enclaves or encapsulated environments that are isolated from remote attackers. Maybe this is one approach, but we really don't know. Yesterday we had a very interesting and great panel on the AI Act. So we can look at private AI as, for example, federated learning. Is federated learning really the way to go? Probably, maybe, but we don't really know. Let's look at the data. Maybe the data are local, yes, but the models are shared. Now, in security, we can attack the models. We can probably extract data, training data. We could, with model inference attacks, we can also perform memberships attacks. We could see if certain data points were included in the training. So there is some privacy leakage we shouldn't be having. And it gets even more interesting. So there are signals that, or signs that you cannot have both. You cannot have robust machine learning models and accurate machine learning models. That may be a trade-off, and the signals are strong that this is the case. Maybe, but we don't know yet, maybe there is also a triangle where you cannot have probably private machine learning models, or robust, or accurate models. So there is a huge trade-off between maybe those three things. Is still a topic of research. So to really understand the impact of regulation, we have to explore further and then create a common language and standards. And how can we do so? I don't know yet, but one way to approach this would include a research community, because to really also reflect the fast evolution of this field. And second, also look at stakeholders with an international global footprint that we can learn from. They sometimes push technology forward and make them those technologies transparent. So we can really look at what works and really learn from those approaches. Yeah. Thank you.
Wonderful. Thank you, Konstantin. And Eric Neunschwander, Head of Privacy Engineering with over 15 years of experience at Apple.
All right, thank you, Jane. I was given two instructions, one, not to speak too quickly, and second, not to speak too long. And these two things seem to be somewhat in tension, but I think privacy is a discipline familiar with tension, so I think this will work out. I hope so, anyway. It probably helps to start by explaining a little bit more about my role or my team's role. And so I lead the user privacy team, which includes privacy engineering. And that means that we work across all products and services at Apple to do what exactly? I mean, certainly privacy by design or data protection by design, certainly to share a privacy culture throughout the company. A lot of these terms, I think, are open to misinterpretation. I mean, if you think that you have designed something and it has whatever privacy it has, maybe that's privacy by design, but clearly we mean something more by that. And so internally, a phrase that we use a lot is great features and great privacy. Because as a technology firm, we need to release something that people are going to find compelling and useful and exciting and fun. It needs to be a great feature. And my team exists to help ensure that we have great privacy along with doing that feature. So that leads us to look at things like data minimization, to make sure that the data that we're collecting is only that which is necessary to provide that great feature. Or use limitations, where we can protect through technical and policy means that the data be used only for that feature. Transparency and control, certainly. And then also a foundation of security, both in the sense of encryption, which we think is very critical, and also in the sense of implementing and having the algorithms be done in a secure way so that these other pieces that we talk about actually have the force that we intend them to have. And that means that in practice, it drives us to do things like do the data processing on a user's device, to leave the data in a state where it's never even collected by Apple, that it remains processed locally on the device that the user has. Or to look at ways that we can disassociate data and have it be set up to just be based on sessions rather than a longer-term identifier, certainly rather than tied back to a user's identity. And so that kind of principles drives us to designs that we hope moves things forward and delivers great features in our products with great privacy. I can give you a lot of different feature examples. I think one that's maybe most relevant to this audience because it combines technology and policy both is app tracking transparency. So this is something that we first announced in 2020, but it may be helpful to go back a little bit and talk about where it came from, which I could take you all the way back to 2008 and iPhone OS 2, but that probably is a little bit too far. And so let me instead talk about our second iteration, which was something that goes by various names. It's called the Advertising ID, or the IDFA, the Identifier for Advertising. And this was something that we introduced as a software identifier, and it has advertising in the name, so you can understand it was to help enable advertising as part of the business model for applications that are part of the App Store ecosystem. And along with the IDFA, we also brought out limited ad tracking, LAT. And this was a switch that a user could flip to show their intention that this IDFA, that identifier, only be used for certain limited purposes, things like anti-fraud, as fraud is a big issue in the digital ad space. But what we became aware of subsequent to releasing this is that the actual compliance throughout the entire ad tech ecosystem, there are many hundreds of companies you've never heard the name of, that this signal wasn't always even being collected and passed on through that long chain of manipulators of the data. And if you're not even providing the signal, then obviously the ability to comply is impossible. And so this led us to take a step back and say, well, in addition to the IDFA, which is one method that is being used for tracking, there are other technologies that have come through in the ecosystem that also engage in tracking. And what seems to make sense is that we actually just bring this kind of user control, a user control that we've done for many other forms of data and sensors on our platform, that we bring user control to tracking as well. And so in June 2020, at our developer conference, we announced this app tracking transparency, which simply says that before a developer engages in tracking meaning data about an individual user or device getting linked to data of another party, so third-party data, not first-party data, but this idea that that data is being linked across unrelated entities for advertising purposes, that before a developer can do that, they should ask the user's permission. And we have a model based in security where the OS can intermediate and provide that permission in a way that's enforceable. So we enforce it technically around this IDFA that I've talked about. But it also has the policy component because it wouldn't do just to say, don't track me this way, but maybe I get tracked other ways. It should be about tracking as a concept that the user has control over. So that was, again, announced in 2020. A number of companies came forward and said, actually, now that we understand this transparency around tracking, we think we can change. We think we can actually cease this process in the ways that our applications work. We need a little bit more time. We have to adapt. And so we ultimately delayed the enforcement to April 2021. So we're now approximately 1 year on later to having that in the platform. We've seen adoption by companies. We've seen companies' behaviors change to track less. We've also seen evasions occur throughout this, and we need to continue our enforcement, and this will be an ongoing process. But I think that this is a case where we were able to both provide something that was technically enforceable at the platform level, but then go beyond it with policy to try to achieve a broader outcome for our users. Thank you.
Thank you, Eric. Now, Lorenzo, going beyond regulation is entering the realm of soft law, something that can be divisive for regulators and stakeholders, but also a complementary form of regulation. Do you think there are privacy gains to be obtained here, and what do you see as the limits and incentives for pushing privacy beyond hard law regulation?
So this panel is concerned with the global governance of privacy, so I think I will split my answer into. I'm a big believer in soft law. I'm a big believer in the capacity of soft law to complement hard law. And we've seen it locally with, for instance, the guidelines of the Article 29 Working Party and the guidelines of the EDPB. And you know it better than I do. If you need to brush up on legitimate interest, you probably pick up the Article 29 opinion. You don't go trolling the case law of the Court of Justice of the European Union. So locally, in Europe in particular, guidelines and other forms of factually soft law have been extremely helpful, in my opinion, for the data protection community. At the international level, things are a bit different because we need to face an even more fragmented power setup, so to speak. So for instance, it's not really my field, but in international environmental law, soft law has been very, very useful to reduce the friction caused by different states wanting different things. This could be a way to harmonize the global governance of privacy, but then again, it remains to be seen how, and I'm not seeing particularly promising steps in that regard in the international arena. But then I don't think that the kind of privacy gain and the kind of data protection we want to achieve is going to be pushed by soft law. It can be complemented by soft law, but I don't think there is an alternative to actual regulation by law, which can, of course, be complemented and expanded. I also wanted to mention the fact that very often when we talk about soft law in the context of very big multinational companies, the topic of self-regulation pops up quite a bit. I have zero faith in the ability of companies to self-regulate in the absence of state law or soft law. But I do believe that there is something to be explored in the arena of meta regulation. There's a great paper by Ruben Bings on data protection impact assessments and meta regulation. And I think in a very technical field like privacy and data protection, one regulatory technique that could work is states, or rather supranational authorities putting together a framework and then data controllers figuring out how to adhere to that framework as well as they can.
Great. Thanks, Lorenzo. Anna, the EDPS has been a key global player in shaping privacy and data protection regulation for many years. The past year was accompanied by emerging legal instruments in the EU that touch upon key privacy values. How do you see the interaction between the EDPS and other regulators now that the interplay between the GDPR and the EU data package reform is at full speed? What are some of the challenges and positives of this interplay?
Thank you. So I would take this question a bit more broadly, because obviously it's not only about the EDPS, but also about the national regulators and the impact of already the soft law, the guidance of Article 29 Working Party was mentioned, and I think should not be underestimated. And the same goes obviously for the EDPB today. And the challenges that the EDPS is facing as all those different new regulatory instruments emerge are very similar to what national data protection supervisory authorities are facing, and also the EDPB by extension. So we have analyzed, I think, all of those new proposals by now. The opinions are publicly available. There are different issues linked to every three-letter acronym, new act. But there are certain themes. So in general, we expect that there will be a certain degree in all cases, a large degree in most cases, of overlap between the GDPR and the new regulations. So they would be different sets of rules that would apply essentially to the same situations or the same processing operations. It may be a good thing, it may be a bad thing, depending on how the final outcome takes care of defining this future interaction, going beyond ideally the, without prejudice to the GDPR, and let's leave the rest to the courts. That's the kind of minimalist approach that was adopted in some of those early proposals, and we have been always very critical of that. We don't think it's sufficient. At the same time, speaking of positives, I think it is good that the Commission, the EU legislator, is trying to address some of the big problems that so far I think GDPR was expected to take care of somehow. But there was a lot of criticism about the GDPR, that it should not become the law of everything, and that indeed there is a good case to try and address lack of competition, dominance by some market players through more competition-oriented instruments, such as the DMA. Arguably, I think there is a good case for the fact that GDPR is not by itself a content moderation rulebook, so there was a good reasons to intervene on that side as well. By the same token, obviously, all the societal choices that go into the regulation of artificial intelligence go way beyond just profiling and automated decision-making in the GDPR. So I think that the good thing is that, a little bit of the pressure that was piled up on the GDPR and on its enforcement with probably unrealistic expectations hopefully will be taken off, because the big market failures will be covered by different types of regulations. But at the same time, well, there is the risk that, again, different enforcement authorities, different governance models will exist, and they may not necessarily automatically fully integrate or build on the competence and the expertise of data protection regulators in those markets. So we will face the risk of possibly diverging outcomes and contradictory enforcement decisions pertaining to the same or very similar operations or similar situations. And this is something that I think should be explicitly addressed in all those regulatory instruments by way of at least explicit provisions governing structured cooperation between those, new ad hoc expert enforcement models and the national DPAs, the EDPS, the EDPB, as the case may be, and explicit provisions for information sharing in specific cases, so that this collaboration is not impeded by, sometimes random national confidentiality clauses and all that, as we have seen very well is the case so far. Thank you.
Great. Thank you, Anna. Alexander, much of the privacy debate has been fueled by civil society, with nonprofit organization and activists sharing the table with politicians, regulators, businesses, and academics. How do you see this interaction moving forward?
I think, first of all, put that back in a little bit of context. This is so important to me. I grew up in the most impossible of circumstances. I shouldn't be here today. I should be either in prison or in a low-paid job somewhere because of the environment that I grew up in. And, the thought that democracy would be in reach of somebody in that situation just simply was unfathomable. But democracy is in reach of all of us, and democracy is a responsibility of all of us. And I use democracy with no funding, no money, no corporate support to change a law in the EU and bankrupt a billion-dollar ad tech company just through sheer grit and will and access to democracy. And taking advantage of that access to democracy, writing to the politicians, making sure that their voice is heard. And I remember back in 2005, even before I started working in privacy, it was explained to somebody that we can't really blame politicians for the actions that they take if the only words that they're hearing are from one side of the argument, right? So if the big corporations are the only voice in the left ear of the politicians and there's no civil society in the right ear, then there's this imbalance, and politicians can only act on the information that they have. They're not experts in all of these issues that we discuss on a day-to-day basis, right? They need people and experts to bring this information to them. So we all have a responsibility to engage in democracy, and democracy is under attack currently. There's no clear indication of that. Democracy in the US has been under attack for several years now. In the UK, in Ukraine, we're seeing democracy under attack by the Russian regime. You know, so there's this desire by certain actors within the international theater to control people and to do things for their benefit and against the good of society and humanity. And democracy is what we use to protect us against that. But at the same time, there are still very few people working within civil society compared to the number of lobbyists working in industry. I remember when we were working on the GDPR from 2012, my understanding was around 30,000 corporate lobbyists descended on Brussels against a handful of NGOs who were working part-time because they had so many different files to work on these issues around GDPR. The imbalance of voice and opinion to the politicians was so vast that there was this chasm between what industry was saying and what civil society was saying. And this became very clear as a result of Lobby Flag. I don't know if you remember this organization at the time, who were looking at the changes and the amendments which were being made. And, you know, traditionally in the EU, we've had the European Parliament who have been very focused on protecting fundamental rights. And then on the other side, we have the Council of Ministers, or the Council of the European Union, which are the representatives of the member states who are pushing their own agendas. And these are often in combat with each other or in conflict with each other. And, you know, we're seeing this time and time again. We saw this with GDPR. We've definitely seen this with the upcoming e-privacy regulation. And there's still a lack of voice from civil society. We need to be spending more time and more attention as individuals. You don't need to be a member of an NGO to lobby your government. You don't need to be a member of an NGO to talk to politicians in Brussels or the European Commission. These things are accessible to us all. This is one of the beautiful things about being in the EU, is that access to democracy is absolutely there. And if a guy from a tiny council house in a poverty and abusive environment can change laws around the world without any financial support, just by exercising his democratic will, then anybody can. All of you can. And it starts at home. It's not just about working in an NGO in Brussels and lobbying the European Commission and the European Parliament. The Council of Ministers, the member states, are the ones that are pushing these aggressive anti-privacy policies. And these are the ones which are disrupting the work of the European Commission DG Justice and making sure that these fundamental rights are enshrined within our Constitution, the European Charter of Fundamental Rights. And if we don't defend against these member states and their agendas by lobbying our politicians at home as well as the politicians here in Brussels, then we're going to continue to see this struggle. I think at one point, I'm a registered lobbyist in Brussels as a privacy lobbyist. I think to this day, I'm still the only privacy lobbyist in Brussels who specifically focus on privacy. There's a lot of wonderful NGOs out there who are lobbying on lots of different issues, including privacy, but to this day, I believe I'm still the only privacy-focused lobbyist in Brussels. And there needs to be more of us, absolutely. So the participation between civil society, which isn't just NGOs, it's each and every one of us within this society, and the political will within and democracy within the EU environment that we all live in and all embrace. We really need to make sure that we push that further and we keep pushing those boundaries and we make our voices heard. Because democracy is real and democracy does save us. And the reason why we have GDPR and the Charter of Fundamental Rights and all these other laws which are there to protect us is because democracy exists. So everybody needs to use their voice. And I think this is the most important thing we need to think about moving forward, is to have that equal representation so that the voice in this ear is equaled out by the voice in this ear. And if we don't do that, then we're at severe risk of losing this thing which is so fragile, which makes us who we are and the society that we are.
Great. Thank you, Alexander. Constantine, security researchers in academic and non-academic environments have been a strong and important voice in the future of privacy. Can you tell us more about the unique space that independent security researchers occupy in promoting privacy and security?
Yes, thank you very much. So let me tell you, so this is my first CPDP I'm attending, and I have really two major observations. First is it's a very welcoming and friendly and open atmosphere, and also still having a very diverse, like a variety of diverse opinions. And the second impression is that I get that is it's very disconnected from my community, which is basically security. So this is interesting. It's like contradicting observations, very welcoming and very open to exchange, but on the other hand, quite isolated from the community I know better. And yeah, so I really propose we need structures and environments to really bring the multiple stakeholders together to communicate, because this is the only way to establish a language, again, on the technical level. And this, again, is the only, seriously, the only basis for fruitful competition and innovation. So I think that would be my proposal to go.
Great, thank you very much. And Eric, do you think there is a fundamental role for companies to play in the global governance of privacy? Can you tell us more about how you see companies pushing things forward in the field and why some businesses have been associated with the opposite image, that of a roadblock to privacy rights?
Well, I certainly have a bias that I think companies have an important role to play. I think there are a couple of examples. I mean, it's both in creating some opportunities and some threats. I mean, you talked about the challenges with federated learning and some of the attacks against data recovery out of the models, which is both an opportunity in terms of improving the features, but then also a new and novel threat. And in response, now we can have private federated learning, where there's privatization both on the inputs and on the centralized model to help defeat attacks like that. And I think both of those have been significantly driven forward by use cases by companies. I mean, they originally emerge out of academia, differential privacy arose out of academia, but then they get productized and used in ways that can improve privacy on top of the features that have already been launched. I think a second example would be biometrics, which is hugely sensitive, and in fact, we've done a lot there with Touch ID and Face ID to really bring biometrics into more common usage. And this is a threat from the standpoint of normalization, but we also thought a lot about that in the design, and we're motivated to do it because at least on iPhone, the fundamental basis of the encryption of your device is based on the passcode. And entering a passcode repeatedly through the day is very annoying, and so people don't want to do this. But through Touch ID and then later Face ID, it becomes easier and easier to still have that passcode, which is the basis of the encryption, but to have a more usable form of that. And in thinking about the sensitivity of the data, we did all the processing on the device, and not only all the processing on the device, but the processing separated from the operating system. There's actually an entire separate enclave processor, we call it, which handles the biometric data processing separate from iOS, separate from any third-party or even Apple application to help reduce the threat to that data. So I think that these are ways that companies move forward in different spaces, which definitely impacts privacy. And companies have different ways to weight that, I guess, and so I think you're right that some of them don't prioritize, or there isn't that culture of privacy that Alexander talked about, and then you get these features that don't have the privacy really considered as part of their initial design, and then you end up with more probably threats than opportunities.
Great, thank you. So we have a bit of time for questions from the audience. Let's see, I see a gentleman in the middle. Oh, good. Up, yeah, back in the middle.
Thank you very much to the panel. So I'm a data protection lawyer, and I have two questions. The first question is about the dialogue you are advocating for between policymakers and tech companies. I do agree to the dialogue, but what about trust? Do you think that dialogue will be efficient when we know that, for example, all the dialogue before leads to some sanctions before cuts? Sometimes big tech, for example, are saying, okay, we will do this, we will do that, but after we just users are complaining and we have like sanctions before a cut. So what's the role of trust in that dialogue? My second question is about the
I
conflict
think
of...
let's take your first, and then we'll move on to the second. I think that might be good. I think it's about the role of trust. Who would like to take it? Okay.
It's trust is a very interesting word, a very interesting concept. I think it depends on how you define trust. I swing between two definitions. The first is that trust is that thing that begins when knowledge ends, and the second one is trust is that thing that begins when security ends. So I think the role of trust is sort of invisible in this dialogue, and it's not something we can really leverage, but it's something we can take into consideration during the negotiation. So to put it a bit bluntly, some companies' business model is extractive by default, and whichever privacy and data protection improvement would hurt their bottom line. So trusting them is fairly difficult. Other companies have a different business model, a different revenue model, and in that case might be easier, but I don't, to be honest, I don't think privacy and data protection in this instance are any different than any other interpersonal relation we have with regard to trust.
Alexander.
I just want to add something here. The week before GDPR came into effect in 2018, a journalist from Politico said to me, what do you think the most important thing is in relation to GDPR? And he was saying, he'd spoken to a number of people in Brussels on this issue, and they'd all said transparency. And I said, no, not transparency. I said, transparency is not the most important thing with GDPR. Honesty is the most important thing in GDPR. And I'm not talking about honesty in the context of transparency. I'm talking about organizations being honest with themselves about what they're doing with data, organizations being honest with their employees and the people that work with them about what they're doing with data, and then organizations being honest with consumers about what they're doing with data. And you can't have trust if it's built on a foundation of lies, right? Because it becomes fragile, it becomes ephemeral. If you want to build trust, which is incredibly important, and I would say is one of the most important things of the modern technological age, and will be a differentiator for companies when it comes to competition. But if that's built on a foundation of lies, then it's never going to work. The problem is many companies lie to themselves. They believe that what they're doing is altruism, or they believe that what they're doing is necessary, without actually thinking about it and being honest about what they're actually doing. They live in this illusion of what they're doing is this bubble almost, that what they're doing is right and should be done. And if they're not honest with each other and that honesty follows the chain all the way down, then that trust is meaningless because it's just going to break. So honesty, I think, is far more important because it's what breeds trust and maintains trust over the long term.
Great. And your second question?
Thank you very much for the answers. And my second question, as a user, when I use my device, I want privacy, I want to be protected, but I also want to beneficiate from good services. So I want to ask how to, to strike the good balance between, okay, the right to be protected in internet and the other end, the right to have good services. I'm talking about, for example, the DMA. The DMA will, apply some obligations on big companies, for example, to allow interoperability. But at the other end, we have some companies which say, okay, to be more efficient in security, we need to control how other service providers are, give, for example, services through our application. So how to do that? I must say to be between all those obligations or those requirements. Thank you.
Great. Great. Will do. So the tension between good services and the right to use the internet.
Yes.
Anybody want to take that one?
Privacy by design is positive sum by design. The very principles of privacy by design say it should be positive sum, not zero sum or negative sum. It should be preventative rather than reactionary. So if you're following the principles of privacy by design in the development of your products and services, this should never be an issue.
Anybody else?
Maybe just to add that, hopefully innovation, or if this becomes an incentive to innovate, to provide better services, in a more interoperable and interconnected world, rather than focusing on how to innovate through, monetizing the masses of people's data better. That's your opening here, I would hope.
I think in general, I would agree with Alexander. The positive sum game will be the best solution. I don't think that's possible in every instance, however. When it's not, I don't see, aside from engineering practices, I don't see anything from the legal perspective. I don't see what could be done other than a case-by-case based proportionality assessment. So it's if I knew how to balance privacy and security in online services, it would be great. But I don't think there's a silver bullet.
Great.
Hi, Svetlana Goltsov from Swift. So I'm very interested. Nowadays, we are all know that about developments in data privacy engineering, data privacy enhancing technologies like homomorphic encryption, multi-party computation, etc. But they are treated usually very separately. I mean, we have data protection regulations, but on the other hand, for instance, AI regulation. And in my understanding, there is some overlapping and sometimes contradictory requirements, right? Like, we want to protect privacy. We have, for instance, homomorphic encryption, but then transparency, for instance, decreases. Or if we have multi-party computation, then how do you exercise your right of data subject to access the right? Because the outcomes sometimes are not really meaningful in between, right? And it feels like there is no enough dialogue between these pieces of legislation and requirements in practice. They sound beautiful when it comes to the practice. What is encouragement to use these privacy-enhancing technologies in the end, and how they should be implemented? What are regulatory developments in this domain, and how would you see maybe the way to go forward? I think this is a question mostly like to Konstantin and Anna. So thank you.
Well, thank you. I think it speaks a bit to the point I was making earlier, that indeed, if we are not careful, or rather if the EU legislator is not careful to carefully, define how the interplay between those different acts should be, we will be in trouble. But that's at the level of legislation. What you're talking about, it's more about implementation on the ground. So probably the level of detail where the legislation would not touch normally, but it will be extremely important to have appropriate guidance, to obviously have appropriate enforcement that would somehow be able to take and balance, if need be, both aspects, and education, and as in some cases there will be implementing provisions that would shape that interaction to a certain extent. Hence my argument, there needs to be a structured role, a more prominent role also for data protection supervisory authorities to be able to input and make sure that other considerations do not systematically trump over privacy and data protection, as these inevitable overlaps or conflicts even will be resolved in practice.
We have 1 minute left, and I'm going to be held to so very quick.
Thank you very much. Ben Avison from RAID, which is the Regulation of AI, Internet and Data Conference. Question about global governance. Legislators are not global, clearly, but corporations are. Apple also, for example, has a direct conduit to customers worldwide. How can you perhaps help legislators to create harmonized approaches to the global governance of privacy?
So how can corporations help regulators look at...
And policymakers create a global governance create policies which are more harmonized worldwide and that are in the interests of customers and that safeguard privacy and generate trust?
Ooh, we have 19
That's a big
seconds
question,
to
sorry.
answer. Anybody want to give a...
That's your job, isn't it?
Well, I think that trying to educate on the technology side, because I think what's driving the regulation is concerns about technology and trying to make sure that that's out there, that people will understand it, that the regulators have that education and background. But harmonization, that's definitely a challenge and primarily not one of technology.
Great.
Thank you.
Thank you very much, and thanks to all of the panelists today.